Our law firm, Holland & Hart, is pleased to provide this presentation and training on the relationship between HIPAA and law enforcement. And we're doing this in conjunction with Greg Rosenbaugh and the Utah Rural Independent Hospital Network. Kim Stanger, whose voice you just heard, he will be presenting this training today. And Kim and I regularly field phone calls from hospitals, including many of you who are participating in this webinar on this issue. You know, you get a law enforcement officer coming in asking for records, you receive a subpoena and so forth. So we get these calls fairly regularly and thought that a sort of a basic training session might be useful for you all. As many of you know, Kim Stanger, who you will be hearing from, is a nationally known expert in the area of HIPAA. Many of you have participated in some of the monthly webinars on various healthcare topics that he presents. And so I'm pleased that he's willing to provide this presentation today. And since this is a one-way broadcast, if you have questions that come up during the course of the next hour, just jot those down and then don't hesitate to call or email either Kim or me with questions, and we're happy to discuss these things further. In addition, we're going to record this webinar, and so sometime in the next few days, maybe the next week, either Greg Rosenbaugh or I will send to each of the hospitals a link to the recording of this webinar so that you can use it in future training at your hospital if you'd like to. Also, my last point before I turn it over to Kim, don't ever hesitate to pick up the phone and call either Kim or me. It's better to err on the side of safety and caution than to violate your obligations when it comes to the disclosure of protected health information. And we're always happy to, you know, field a short phone call to confirm that you're responding to any request in an appropriate way. So with that said, I'd like to introduce Kim Stanger, and I will turn the controls over to Kim. Thanks, Kim.
Thanks, Blaine. Good afternoon. Good to have you guys on the line. Today we're going to be talking about HIPAA and law enforcement, just as Blaine said. Hopefully in the email that you received, you were given copies of written materials that we've made available, some helpful resources for you in addressing these issues. We've given you a copy of the OCR's HIPAA Privacy Rule Guide for Law Enforcement. This is the updated two-page outline that the Office for Civil Rights, which are the HIPAA police, has given concerning disclosures for law enforcement purposes. We've also given you a copy of the Utah HIPAA Law Enforcement Task Force summary of disclosures of protected health information to law enforcement. This is a very helpful summary for you guys in Utah, which is all of you, concerning the HIPAA obligations. And this was actually written back in 2005. I understand that the task force is working on an updated version of that. If and when that comes out, we'll see if we can get that out to you. But in the meantime, this is kind of the latest one that we have. We've also provided to you a copy of the task force authorization that they prepared for law enforcement. So sometimes law enforcement may not come with formal process. They may just give you a written authorization, and there's a sample form for you to use. We've also given you a couple of client alerts that I drafted dealing with disclosures to law enforcement and responding to subpoenas, orders, and administrative demands. So hopefully that those written materials, in addition to the PowerPoint today, will give you what you need to respond when the law enforcement shows up at your facility. A few preliminaries. First, this is an overview of the relevant laws. We're not going to get into all aspects of HIPAA today. We're just going to be talking about its intersection with law enforcement. Also, remember that HIPAA preempts less restrictive state laws. So to the extent that HIPAA places a limitation and it's more restrictive than the state law, then you got to comply with HIPAA. To the extent that you've got a state law that may allow you to make disclosures that aren't otherwise permitted under HIPAA, then you got to comply with HIPAA. HIPAA is the floor of patient privacy. If there's a state law that's more restrictive, you go with the state law. If the state law is less restrictive than HIPAA, then you go with HIPAA. We're going to focus on the disclosures to law enforcement. There are additional rules that could apply in other situations. For example, you may get subpoenas in civil litigation or maybe in the agency inspections where the Board of Medicine shows up or the Department of Health shows up. different rules generally apply in those situations. We're going to be talking really about the law enforcement situation. Finally, as Blaine mentioned, if you have questions through this program, you can send them to me using the chat feature, and I'll try to take a look at those before the end of the program. Alternatively, you can, I'll follow up if we don't have time with any of the emails you submit via chat feature or via email. I'll follow up with those after the program. All right, with that said, let's talk about law enforcement. What do you do when this guy shows up at your facility? Well, the problem is that law enforcement, they may show up, but just remember that their job is to catch the bad guys. They're there to investigate. They don't know HIPAA, and quite frankly, in some cases, they really don't care about HIPAA. They're there to do your job, and sometimes either out of ignorance or simply because they want to get their job done, they may bully you into telling you you need to make disclosures to HIPAA. And quite frankly, they will tell you things that may not be accurate. But even though they are the police, you are still subject to HIPAA. That means that if you make disclosures improperly, you can get hit up with fines or penalties ranging from anywhere from $100 to $50,000 per violation. If you act with willful neglect, it's a mandatory fine of at least $10,000 to $50,000 per violation. That's if you correct it within 30 days. If you fail to correct it within 30 days, the mandatory fine is at least $50,000 per violation. That's the bad news. The bad news is it's a mandatory fine if you act with willful neglect. The good news is as long as you're not acting with willful neglect and you correct it within 30 days, hey, that's an affirmative defense. The Office for Civil Rights can't impose a penalty. Now, you still may get sued by the patient or others, but at least the Office of Civil Rights isn't going to come after you for penalties in those situations. Now, if you listen and apply the rules that we're going to talk about today, there's a good chance that you will not act with willful neglect, and therefore you can avoid any penalties, even if you make a mistake in dealing with law enforcement. In really bad cases, HIPAA can also impose criminal penalties. You can go to jail for HIPAA violations, but that probably isn't going to come up too much in dealing with the police. You're probably more concerned, in addition to the civil penalties, about some additional consequences. In addition to the Office for Civil Rights showing up, the State Attorney General could sue you for HIPAA violations of $25,000 per violation, plus you have to pay their costs. Individuals may sue you for violating their HIPAA rights. There is no private cause of action under HIPAA, but in Utah and in other places, it has been argued that HIPAA essentially establishes the standard of care, and if you violate HIPAA, then that becomes negligence per se or evidence of negligence, so they will sue you for their damages. More concerning is you've got to self-report breaches of unsecured protected health information. So if you've got a situation where you make an improper disclosure to the police, then you may have to report that to the patient, and the patient, not only the patient, but to HHS. And they may come after you for doing those improper reports. Even if you're not worried about those other people, if you've got an employee that violates HIPAA by making improper disclosures, even if they have good intent, even if they thought that, hey, I was just trying to do what was right by notifying the police, if they violated HIPAA, then you've got to impose sanctions against them. That doesn't necessarily mean you have to fire them out of the box, but you have to impose and document appropriate sanctions, or else you could be deemed to have violated HIPAA. So, because of those penalties, we've got to make sure that we act properly when dealing with the police. So, when that police shows up, or when something happens and you wonder whether or not you can call the police, what is the analysis? Well, here's basically the HIPAA analysis. First, ask yourself, hey, does HIPAA even apply to this request for information? Are you acting in your capacity as a covered entity or business associate with regard to this information? Does the request seek protected health information or other type of information that's really not covered by HIPAA? Assuming that HIPAA applies, does HIPAA allow the disclosure? Does the officer even have the authority to request or obtain that information? Is there a HIPAA authorization that would allow you to make the disclosure? And if there's not a HIPAA authorization, is there an exception under HIPAA that would allow you to make the disclosure to the police? And even if HIPAA allows the disclosure, you got to ask yourself, well, should you make the disclosure? Because HIPAA generally does not require disclosures. It just says you may make the disclosure. So is there, aside from HIPAA, another law that either requires or prohibits the disclosure? And even if you want to go ahead and make the disclosure and HIPAA allows it, HIPAA generally says you can't disclose more than you have to for that intended purpose. So you kind of have to consider those questions as you're going through the analysis. So first, does HIPAA apply? Well, HIPAA applies to only certain entities. Generally, it applies to covered entities and business associates. Covered entities are healthcare providers who engage in certain electronic transactions, as well as health plans, including group health plans, if it has 50 or more participants or is administered by a third party. So HIPAA would not only apply to you in your capacity as a hospital, but to the extent that you also have a health plan relevant to your employees, HIPAA would apply to your health plan in most cases. But it only applies to you if you're acting in your capacity as a healthcare provider. So for example, if the police show up and want information about one of your patients, then HIPAA is probably going to apply. On the other hand, if they show up and want information about your employees, and it's not their health information that you maintain as the hospital as their provider, but just simply as their employer, well then HIPAA doesn't apply to that. You may have other laws or confidentiality protections that may apply, but HIPAA would not apply to those particular situations. HIPAA also applies to business associates of covered entities, those entities whom you want to do stuff with your protected health information. To the extent that you are acting as a business associate for another healthcare entity, maybe you're doing billing or records maintenance for other healthcare providers in your area, then HIPAA would also apply to you in your capacity as a business associate. So if the police show up and want that information that you received from another covered entity, then you're going to also have to comply with HIPAA in dealing with the police on those situations. Well, what kind of information does it apply to? Does it apply to all information that you may have? No. HIPAA only applies to protected health information. Now, protected health information is very broad. That's information that may be reasonably be used to identify an individual relating to their health, healthcare, or payment for their records. So it's medical records, bill information, those things. It's not information that's unrelated to their healthcare or payment. So for example, if they showed up and again wanted information about your employees in your capacity as your employer, well, that's not protected health information because it's information that you have that's not related to the patient's health care. It's about your employees. So HIPAA would not apply to that. HIPAA applies to the information if it's created or maintained by a covered entity. Notice it's created or maintained. If the police show up and they want information that you got, it doesn't matter that you got that from somebody else. You may have an obligation to disclose that under HIPAA, even if you are not the one that created it. And it applies to the information in any form or medium, whether it's paper, electronic, oral, whether it's photos, whatever it might be. So protected health information is very broad, but it's information about your patients, not about your employees or other third parties. So let's assume that HIPAA applies, and you got to ask yourself, does HIPAA allow the disclosure? Well, here's the general rule for HIPAA. The general rule is this: there is no general exception that just because the police want it, they get it. There is no general exception for law enforcement purposes. The general rule under HIPAA is that a covered entity or business associate may not use or disclose protected health information unless it's for purposes of treatment, payment, or healthcare operations, which usually is not going to apply in disclosures to police. So you would want to have a written HIPAA-compliant authorization or an exception that would allow you to make the disclosure to the police. Now, there are no general exceptions for disclosures to law enforcement, but there are some specific exceptions that apply depending upon the particular circumstances. So you have to satisfy certain criteria before you can make the disclosure to the police. Let's talk about those exceptions now. We'll run through those. The first is HIPAA allows you to make disclosures to avert a serious threat of harm. You may disclose protected health information if you believe in good faith that the disclosure is necessary to prevent or lessen a serious and imminent, note that's imminent, threat to health or safety of the person or the public. You make that to a person who's reasonably able to prevent or lessen the threat, including the target of the threat. So that would allow you to make disclosures to, for example, the police, but not necessarily call up Geraldo to report it on the news. And that disclosure has to be consistent with applicable law and ethical conduct. So this is the situation where if you think that you need to make the disclosure to the police to protect people against a serious and imminent threat of harm, then you can go ahead and make that disclosure. For example, you may have somebody come into your ER, they're high on Demerol, and they decide that they want to go home. You know that they shouldn't be driving. They go out, they get in their car, and you think, gee, I wish I could call the police because that guy's going to kill somebody, but, you know, because of HIPAA, I can't call. No. This exception allows you to go ahead and make that disclosure as long as you satisfy those criteria. Now, the good news, too, is the regulation specifically says that the provider is presumed to have acted in good faith when it makes that disclosure, so long as you're making that based on your own actual knowledge or a credible representation by someone else with knowledge or authority to make that. So you have deference there. So the bottom line here is, if you think you need to call the police to protect people against serious and imminent threat, not just some undefined threat in the future, but serious and imminent threat, then you can go ahead and do it. HIPAA also allows you to make certain disclosures if you believe in good faith that the disclosure is necessary for law enforcement to identify or apprehend an individual under two circumstances. First, because of a statement by an individual admitted that, so maybe example, you're providing care to a patient, and in the course of that care, that patient admits that they shot somebody or committed a violent crime against somebody else, and you reasonably believe that that may have caused serious physical harm to the victim. In that situation, you can notify the police to apprehend the person. Or if it appears that the individual has escaped from a correctional institution or from lawful custody, in those situations, you can notify the police. Note, that is not just a general exemption that allows you to call the police anytime you think somebody should be picked up, or maybe you think that there's a warrant out for this guy's arrest, or a warrant out for because of parking violations or something like that. You have to satisfy those criteria. HIPAA also allows you to make disclosures to the extent that disclosure is required by another law. So if there are state laws or other federal laws that require you to make reports to the police, then HIPAA says, fine, you can go ahead and do that. Just make sure you limit the scope of your disclosure to the scope that's allowed by that other law. Note that this only applies if the other law requires the disclosure. If the other law simply allows you to make the disclosure, then HIPAA wouldn't, this exception under HIPAA would not allow you to go ahead and make that disclosure. Remember, HIPAA preempts less restrictive state laws. So even though another law allows you to make the disclosure, under HIPAA, this exception would not apply because it only applies if you are required to make the disclosure. Case in point, some states have laws which will say that a healthcare provider may, they're not required to, but they may report to either law enforcement or the Department of Motor Vehicles if they're treating a patient and they think that that particular patient, maybe it's an elderly person, that their eyesight isn't the best and that they shouldn't be driving. In this situation, because that law allows the report, does not require it, then HIPAA would preempt it, and this particular exception under HIPAA would not allow you to go ahead and make the disclosure under this exception. Now, important point, you only need one HIPAA exception. So even though in this particular, under that particular state law, you wouldn't be able to make the disclosure under this exception, if you thought that that person driving posed a serious and imminent threat, then you could go ahead and make that disclosure under a separate, that other HIPAA exception. What are some laws under Utah law that require you to make disclosures? Well, healthcare providers generally have to disclose or report to the police if they're providing treatment for certain types of injuries, including knife wounds, guns, explosives, infernal devices, or deadly weapons, or if you're treating a victim of a criminal act. And in that situation, you've got to make a report to the police. And the statute sets forth the information, the type of information and circumstances for making that report. Utah law also requires you to report child abuse or neglect. It requires you to report vulnerable adult abuse, neglect, or exploitation. There's also a separate one that mental health care therapists are required to go ahead and make a disclosure to the police if a patient communicates to the therapist an actual threat of physical violence against a clearly identified or reasonably identifiable victim. Those are situations where Utah law requires you to make the report, and HIPAA says fine. If Utah law requires you to make the report, go ahead and make the report. Just make sure that you don't report more than is necessary under the applicable law. Now, there are additional reports that may be required to other entities besides law enforcement. For example, you may have to report communicable diseases to the Department of Health. There are certain circumstances you have to report to the pharmacies, or the Department of Health. Pharmacies have to make reports to the Department of Health, those types of situations. I'm not going to get into those. Just realize that this same provision would apply there. To the extent that Utah law requires you to make the report, HIPAA says that's fine. HIPAA has a specific exception that allows you to go ahead and make disclosures for reporting abuse or neglect. For child abuse, you just follow the Utah statute. For vulnerable adult abuse, follow the Utah statute. But if there are other types of abuse that aren't necessarily specified in the Utah statute, HIPAA says you can still go ahead and make the report, but it's conditioned on a couple of things. You can go ahead and make that report for abuse, even if it's not vulnerable adult abuse or child abuse, if the individual agrees to the disclosure or the disclosure is required by law. But when you make the disclosure for vulnerable adult abuse or for other types of abuse, you must promptly inform the patient of the disclosure, the fact that you made the disclosure, unless you determine it's not in the best interest of the patient to do so, or the person that you would be making the report to would be the personal representative because the patient's incompetent, and you think that that personal representative is the abuser, then in that situation you wouldn't have to inform them that you made the report to the police. Otherwise, in the case of vulnerable adult abuse or other types of abuse other than child abuse, you're supposed to inform the individual that you notified the police of the report. HIPAA would also allow you to go ahead and make disclosures if the police show up with the patient's written authorization to turn over the information. That may occur in certain circumstances where the victim is cooperating with the police. They want you to get their information, and therefore they'll give you a written authorization that allows you to make the disclosure. Just make sure that that authorization you receive contains the elements that are required by HIPAA that are set out in 45 CFR 164.508. That form that I gave you is a good outline that summarizes the elements that need to be included in the authorization. You may want to use your own authorization. Just make sure it contains these elements. The authorization has to identify the information that's going to be disclosed. It has to identify the entity that's authorized to make the disclosure, presumably you or your employees. It's got to identify the entities to whom the disclosure may be made, for example, to the law enforcement. It's got to state the purpose of the disclosure. Now, if it's the patient who's requesting the information, it's sufficient if the authorization simply says that the disclosure is made at the request of the individual. It's got to state an expiration date or event. So if this is an investigation into criminal conduct, the authorization may say, instead of a particular date, it may say that this authorization is valid until the police conclude their investigation or until any criminal action is resolved. And something that's often left out of these authorizations, they've got to contain certain statements concerning the patient's rights, specifically that the patient has the right to revoke the authorization at any time, that the provider, you can't condition the treatment on the authorization with certain limited exceptions, and the information may not be protected once it's disclosed, so it may not be prevent redisclosure of the information. You have to have that information in there in order to have a valid HIPAA-compliant authorization. If the authorization doesn't comply with HIPAA, with all of these elements, then it would technically be a violation, and it could potentially be a reportable violation. Probably you're not going to get up with fines or penalties. The government has indicated that the failure to include all of the necessary requirements may not be willful neglect, but it's better just to make sure that the authorization contains the required elements. As I mentioned, the government, I've given you a copy of this Utah authorization that was prepared by the Utah Task Force. You may want to use that, or at least compare it to your authorizations if the police show up with the authorization. All right, there's another exception where HIPAA says that you can go ahead and make disclosures of certain limited information for purposes of a facility directory. This is basically the exception that allows your pink lady at your reception desk to, when somebody shows up and asks for the patient, that they can tell the person who's visiting where that patient is. The rule is this: you may disclose limited information as part of a facility directory if you inform the patient that the provider would include that information in the facility directory and gave the patient a chance to restrict the disclosures and the patient did not object. Now, a lot of times when you do the registration, you may not think to ask the patient whether they want to be listed in the facility directory. However, hopefully all of you are given the patient a copy of your notice of privacy practices. That notice of privacy practices presumably has a statement, something to the effect in it that you are going to use or disclose their information for purposes of the facility directory unless the patient objects. And if the patient doesn't object, you'll go ahead and use it. As long as you've got that in your notice, then you should be fine. If the patient objects to using their information in the facility directory, you can't use it in the facility directory. If they don't object, however, you can disclose the information as part of the facility directory. The information you can disclose, though, is limited to simply the patient's name, the patient's location in the facility, and the patient's general condition. And you can only make this disclosure if the person shows up and asks for the patient by name. So, for example, if you have the police that shows up and says, hey, we're looking for Blaine Bernard. We are wondering if Blaine Bernard is in your facility. This exception would allow you to go ahead and make that disclosure, but you could only disclose the patient's name, the patient's location in the facility, and the patient's general condition. On the other hand, if the police show up and say, hey, we're looking for somebody who may have suffered a gunshot wound, have you got any victims of a gunshot wound in your facility? Well, this exception would not apply because they have not asked for the patient by name. It's possible another exception might apply, but this exception would not apply. All right, there's an exception for health oversight agencies. So if the OIG or the Department of Justice or the state fraud unit shows up and they're investigating some kind of healthcare fraud, this exception would allow you to go ahead and make disclosures to them. That's not your normal law enforcement purpose, though, so we won't spend a whole lot of time on that one. There's an exception that allows you to make disclosures per orders or subpoenas that are part of a judicial or administrative proceeding. Now, the rules here are different depending upon who's issuing that order. If that order is from a court or administrative tribunal, meaning that it's signed by a judge or a magistrate, then you can go ahead and make the disclosures per that order. The judge or the magistrate, they're the law. They're in charge of interpreting the law. If they tell you to do something, you've got an order that's signed by a judge or magistrate, and that judge or magistrate has jurisdiction over you, then you can go ahead and disclose it. You don't have to worry about it. On the other hand, if you receive a subpoena, discovery request, or legal process that's not accompanied by a court order or signed by the judge, instead it's just signed by another attorney or signed by the clerk of court, well, then the rules are a little bit different. In that situation, you can only go ahead and disclose that information if you take certain steps to make sure that the patient has been given notice of that subpoena and has had a chance to object, and either the objections have been ruled against or the time for objections have passed. So you want to give notice. The difference there is if the law enforcement has gone to the court, then you've had an independent entity, this independent judge or magistrate, make the determination that, yeah, you can get that information. If you're just getting a subpoena from that attorney's not there to look out for the patient's interests, and therefore we want to have some additional protections. Now, you can get that additional assurance from that person issuing the subpoena or satisfy this obligation in one of three ways. The first is you can have that person issuing the subpoena give you written assurances, written satisfactory assurances that they've given the notice to the patient and the time either the objection has been ruled against or the time for objecting has passed. So you can get something in writing from them. That doesn't happen very often. Usually the easiest way to handle this when you get a subpoena that's not signed by a judge is simply for you yourself to go ahead and send a copy of that to the patient and tell them, hey, we got this subpoena. We're going to go ahead and have to produce this information unless you do something to protect or quash this subpoena before then and let us know in advance. Once you've given that patient that notice, then it's their obligation to go ahead and take action, and you don't have to worry about it too much. You can go ahead and then comply with the subpoena. Just make sure you don't comply early or disclose the information early. Make sure you comply with the strict terms of the subpoena. You can also satisfy it if an appropriate protective order is in place, but that doesn't occur all that often. All right, that's the way to handle general judicial or administrative proceedings. Well, what about if law enforcement shows up with a warrant or an order in a specific law enforcement case? Well, again, HIPAA says that you can make the disclosure to the extent that they come with a court order, warrant, or subpoena or summons that's issued by a judicial officer, meaning it's signed by a judge or magistrate. I've had situations where a prosecutor will issue a subpoena and they say, well, I'm a judicial officer, therefore you need to produce it pursuant to this subpoena, and you don't need anything else. That is not correct. When you look at the commentary, it's relatively clear that by judicial officer, they're talking about a judge or a magistrate. They're not talking about a prosecutor who really is a law enforcement official. You could also disclose the information if you get a grand jury subpoena. You don't need anything else. If it's in a grand jury case, you don't need the additional written assurances, because everything that occurs in a grand jury proceeding is confidential anyway, so there's already protections in place to protect that information. You can also produce the records if you get an administrative request, subpoena, summons, or demand authorized by law, so it's not issued from a court. Instead, it's issued by an administrative agency. Maybe it's a Department of Justice or an OIG civil investigative demand. In that situation, you can produce it if the info is relevant and material to the legitimate law enforcement inquiry, and the request is reasonably specific and limited to the purpose for the inquiry, and the person who's issuing that request confirms that de-identified information could not be used. How do you know whether they satisfy this criteria? You ask them, and you're entitled to rely on, in good faith, on their representation. So if you get an administrative request, not a court request, not a criminal action, but an administrative request from an administrative agency, then that's the standard for responding to a subpoena, summons, or administrative request in those situations. Okay, sometimes quite often as a matter of fact, you may have the law enforcement show up and say, hey, we're looking for a particular person, and can you help us out here? They don't show up with a warrant, they don't show up with a subpoena or anything like that. They're just trying to track down somebody. They haven't gone to court to get that. Well, HIPAA says that upon request from a law enforcement, if they show up, you can go ahead and disclose limited information to help identify or locate a suspect, fugitive, witness, or missing person. You can only do that if the police request that information. If they request that information, then you can go ahead and disclose certain information, but it has to be limited in the type of information you disclose. You can only disclose the information that's in the list on the screen. The name and address of the person, the date and place of birth, social security number, blood type and RH factor, type of injury, date and time of treatment and or death, and certain description of distinguishing characteristics. You can't then go beyond that and disclose a whole bunch of other stuff. If they want the other stuff, you would have to tell them, unfortunately, HIPAA prevents us from disclosing the additional stuff, but if you go back and get a warrant or an order or can identify another HIPAA exception, we would be happy to help you. Now, this applies only if the police request the information. I've had situations where the police have kind of like a blanket request. They go in and say, hey, anytime you have a motor vehicle accident, we want you to call us. That is not what this is designed to cover. It would cover, however, situations where you get media alerts or wanted posters or things like this where the police let you know that, hey, John Doe has escaped from prison. We're looking for this guy. If you see him, you contact us. In that situation, you could contact them and disclose this additional information because that is in response to a police request. Under HIPAA, you can, if the police request it, disclose information, limited information about a patient suspected to be the victim of a crime other than abuse. If it's an abuse case, then you're governed by those other statutes and the other regulations. But if it's a victim of a crime other than abuse, you can disclose it if certain conditions are satisfied. First, if the patient agrees to disclosure, you can go ahead and disclose it. So you'd ask the patient, hey, the police, do you mind if I disclose information about you to the police? If they say yes, then fine, go ahead and do it. On the other hand, if the patient's unable to agree because of incapacity or it's an emergency situation, and the police represent you, they tell you, hey, we need this information immediately in order to determine whether or not somebody else violated the law, and it's not going to be used against the patient, it's to catch somebody else, and they represent that they need it immediately in order to catch the person, and you otherwise determine that it's in the best interest of the individual, then you can go ahead and make the disclosure. The key there is that it's in response to the request for information from the police. It's not something necessarily that you initiate. If you're going to initiate it on your own, you have to fit within another exception. There are other exceptions that may apply, including that one that requires you under Utah law to disclose treatment to victims of crimes or victims of certain violent acts like gunshot wounds or knife wounds or those types of things. HIPAA would allow you to make disclosures if you think that the death resulted from a crime. You may disclose the information about the decedent to law enforcement for the purposes of alerting them to the death. Now note here, it doesn't tell you the kinds of information that you can disclose. So you're going to want to disclose the information, the minimum necessary for purposes of that. You may disclose that, hey, we've got somebody here, they died, we think that it's related to a crime because of blah, blah, blah. You may say that, but be careful about going too far beyond that. If the police need more information, they can come back and identify another exception or get a warrant that will allow them to get the information. If you think that a crime has occurred on your premises in the hospital, then you can go ahead and make that disclosure to the police so that they can come in there and respond to the crime that's committed on the premises. Note that this is limited to a crime on the premises. Just because the crime occurred someplace else does not allow you to use this exception to notify the police. You'd have to find another exception or not make the disclosure. Remember that your job there at the hospital is taking care of people. You're there to protect people, to take care of patients. You are not there as an arm or agent of the police. In fact, it can inhibit your ability to provide care for patients if the patients think that no matter what happens, you're going to turn them into the police. So you've got to be careful about becoming the agent of the police. You've got to limit the disclosures to the extent allowed or permitted by HIPAA. There's also an exception that applies if you provide treatment away from the hospital premises in an emergency situation. So maybe you're driving down the road, you see that there's this serious accident, you hop up and you start to help as a healthcare provider, and you discover, oh my goodness, this person was shot or whatever. In that situation, you could go ahead and make this disclosure under this particular exception. You make the disclosure if it's necessary to alert law enforcement to the commission and nature of a crime. You can disclose the location of the crime or of victims and or identify the description, provide the identity, description, and location of the perpetrator. Note that this only applies if you're away from the hospital and you're providing care in an emergency situation. It would not apply, HIPAA wouldn't apply if you just see a crime that occurs and you're not otherwise engaged as a healthcare provider in providing treatment, then HIPAA simply wouldn't apply, and you can go ahead and make whatever report you want to because HIPAA doesn't apply in that situation. HIPAA would also allow you to make certain disclosures about persons who are in custody, police custody, or if the jail brings in somebody to receive treatment. You may disclose information about an inmate or other person in custody to law enforcement or a correctional facility if the official represents that the information is necessary to provide health care to that particular person, for the health or safety of that individual or other inmates, for the health and safety of officers or employees at a correctional facility, for the health and safety of officers transporting the prisoner, or safety, security, and good order of a correctional institution. They give you some pretty broad leeway in making disclosures about people who are in police custody in order to make sure everybody stays safe. Note that that no longer applies once the person's released from custody. Once they're released from custody, there aren't the same safety concerns, and therefore the police would have to come up with a separate exception. You may have a situation where one of your employees wants to go ahead and make a disclosure to the police. In that situation, you're not deemed to have violated HIPAA if one of your members of your workforce who is a victim of a crime discloses the information to law enforcement, but the information that's disclosed has to be limited to the information that's up there on the screen. It has to be information about the suspected perpetrator of the crime, and the information is relatively limited in what can be disclosed in that situation. If that employee goes ahead and does that, makes that disclosure inconsistent with it, or consistent with these limits, then you as the healthcare provider are not deemed to have violated HIPAA. If they go beyond that and make a bunch of other disclosures, then there may be a question about whether or not you properly train them and whether or not you could be liable for what they did. The key there is to make sure you train them concerning what their obligations and their limits are. Similarly, if one of your members of your workforce is a whistleblower, they want to make accusations to the police or others because of something that's going on, that workforce member believes in good faith that the provider has violated the law or has endangered others, and the disclosure to a health oversight agency or police is authorized, that the police are authorized to investigate and respond appropriately. If they go ahead and make that disclosure, you're not responsible. You're not deemed to have violated HIPAA if they make that disclosure. There's another exception that applies to certain public health activities. It really doesn't apply in the context of the law enforcement very often. It's just the type of thing that if, for example, the Board of Medicine shows up or FDA wants some information, this is the exception that allow you to make disclosures in those cases. All right, those are the general exceptions that apply in making disclosures to law enforcement. Those are outlined in the materials that I provided to you in addition to the regulations themselves, so that should give you a good background on how those exceptions apply. Now, let's talk about how you put those into practice. What do you do? Well, again, the general rule is just because the police show up and want it doesn't necessarily mean they get it. You still got to comply with HIPAA. And if you have concerns or questions about the disclosure to law enforcement, explain that to law enforcement. Explain that, gee, we really want to help you, but we've got these HIPAA obligations. Therefore, we need to verify that we can make these disclosures under HIPAA. If the officer says, no, you can go ahead and do it, I know HIPAA, you can just politely explain to them, well, thanks very much, but our protocol is we need to check with our internal persons. On the other hand, if the police says, no, I want you to get out of my way, I'm going to go in there right now, never, ever get in their way. Never physically obstruct the police, misrepresent facts, or affirmatively take action to hinder law enforcement actions. You don't want to hide the patient, move them from room to room to keep them out of or away from the police. You don't want to do any affirmative actions. You want to state your objections, document your objections as necessary, but if the police are hell-bent on proceeding, then get out of their way, document it, and don't get in the way of what they're doing. If you do, then you could be liable for obstruction of justice or other situations. As long as you assert your objections, you document that, then you're not going to be responsible if the police go beyond those objections and do what they probably shouldn't be doing. If you have any questions about what you can or should disclose, contact your privacy officer or contact your attorney. Okay, that is the overall general rule. Let's talk about more specific stuff. The best thing for handling these situations with law enforcement is to prepare in advance. Make sure that you include your disclosures, that you may make disclosures to law enforcement as part of your notice of privacy practices so that your patients know that. As part of the notice, you're supposed to tell the patient and give them notice in advance of potential exceptions under HIPAA that will allow you to make disclosures. Make sure that disclosures to law enforcement are included in your notice of privacy practices. Then establish your policy or process for responding to request from law enforcement. Among other things, you'll want to identify the person who's responsible for either contacting or responding to law enforcement requests. So if the police show up, you know who to contact to have them deal with the police. The person should have a good understanding of the facts and the law that we've talked about today. Now, is that the charge nurse, is it the administrator on call, or is it a privacy officer? Whoever it is, make sure that they understand the applicable rules. And make sure that your people are trained so that if the police show up, that they know to contact the responsible person as soon as possible. You don't necessarily want a tech or a frontline nurse who isn't trained in this stuff responding to these requests from the law enforcement because they may not know the rules, probably don't. You may want to sit down with law enforcement, local law enforcement, in advance and explain to them, hey, we've got these HIPAA rules that limit our ability to make disclosures. If you show up, this is what we're going to need from you, so that they're aware of this, and work this out in advance so that there's a protocol, there's a process in place for addressing these issues. That avoids the stressful situation where they show up all of a sudden in the middle of the night and demand information. You're going to want to train your personnel concerning the process, both to ensure that they comply with it and also to document that if they violate it, you did everything you should have, and therefore you're not liable for willful neglect penalties. Because if you have your policies and procedures in place, you train your people, and then they screw up, that's not willful neglect on your part. So you want to train your people about how to interact with law enforcement and document that training. If that police officer shows up, under HIPAA, you've got an affirmative obligation to verify the authority of the person requesting the information if you don't know who they are. Now, that means you just have to take reasonable steps. So, for example, if the police officer shows up, you're going to want to verify their identity by, for example, checking their badge or asking for papers to confirm who they are. If there are certain circumstances where HIPAA allows you to make disclosures that it's conditioned upon you obtaining certain assurances, then you've got to make sure that you get those assurances. So, for example, if you get a subpoena, generally you can't make the disclosures per the subpoena unless either you've contacted the patient or you get the written satisfactory assurances from the person providing that subpoena. So you'd want to make sure that you get that before you make the disclosures. Now, that limit on verifying the authority or the identity of the person doesn't apply if they show up and just ask to see the person or ask if the person's in the facility. They're going to rely on that facility directory exception. In that situation, you don't have to verify who they are. So the police show up, they show up at the pink lady and say, is John Smith here? That pink lady doesn't need to have them pull out their badge or show them who they are. She can treat them just like anybody else who shows up and asks for the patient by name. She can disclose limited information about the patient's name, their general condition, and their location in the facility. Well, how do you know whether that police officer is lying to you? Well, quite frankly, you really don't need to care. That's not your obligation. You can rely on the representations they make so long as their representations are objectively reasonable under the circumstances. When they show up, you should verify the authority of the requester. Make sure that they have jurisdiction to be requesting this stuff. So, for example, if you've got an Idaho police officer who shows up in a Utah hospital wanting information, well, that Idaho police officer generally doesn't have jurisdiction in Utah and therefore would not have the authority to go ahead and request that. So as part of your verification, you want to confirm that they have the required authority. You can rely on their reasonable representations. If you have questions, then you can check with your attorney. Now, HIPAA allows you to require a warrant. Remember, we have the Constitution here. The Constitution of the United States generally protects against warrantless searches and seizures because generally just if the police show up and say, give me all your records or give me this information or that information, you can object to that. You can refuse to that in general. That's what the U.S. Constitution protects. Now, as a practical matter, we generally want to cooperate with the police, so be careful about saying, no, come back with a warrant. We generally want to cooperate with them. In addition, there may be certain situations where the police are entitled to that information, including situations where the report is required under state law. You may require a warrant, you may tell them you're not going to disclose it, but you could be in violation of those other state laws if you fail to disclose it. Again, though, even if it's a situation where you want to require a warrant, you tell the police, you know, we want to cooperate, but we're going to have to require a warrant before we're going to turn over all of those records. If the police say, I'm here, I want that information now, and they pull out your gun, then go ahead and give it to them. Do not physically interfere with, never lie to, or affirmatively hinder law enforcement if they make those demands and proceed over your objection. If the police show up and just are searching around for general information, again, they're generally not entitled to that information. HIPAA would allow you to make disclosures in certain circumstances like we've talked about, but in general, HIPAA does not require you to make disclosures. Before you make those disclosures in those permissive situations, make sure that that police officer certainly has the authority and it's proper to make those disclosures, and make sure that you have a HIPAA exception. For example, was the disclosure necessary to avert harm? Is there a law that requires your report, or do you fit within one of the other exceptions that allow you to make the disclosure to the police, even for informal requests? Now, if the police show up and they are demanding information and they can't fit within one of those exceptions, you need to explain your HIPAA obligations to them. Explain that HIPAA, hey, we'd really like to help, but HIPAA prevents us from making these disclosures to you. If we do, we can be hit up with mandatory fines of $10,000 to $50,000 per violation, and you can understand that, you know, we simply can't do that. Sometimes the police officer, they don't know, they don't respect HIPAA. In that case, it might be helpful to give them a copy of that document that we provided, that Utah task force that was published on the AG's website, the Utah Attorney General website. Say, hey, it's not just us making up this stuff. Here's the document from the AG's office that explains our limits on our ability to provide information to you. If that police officer is belligerent, they're still demanding the information, you may ask to speak with their supervisor and explain the HIPAA limitations to the supervisor, and hopefully they'll be more reasonable. You may want to contact your own attorney to help in that, respond to those types of requests. At the very least, you're going to want to document that you made the objections to the police officer. If that police officer is insisting on getting that information over your objection, or is going to walk right past you to get that information, you may want to document those facts along with the police officer's badge number. Say something, okay, police officer, if you're going to do it, I'm not going to stand in your way, but let me just make sure I've got your name right, because I'm going to include it on the complaint and when we take this up to the supervisor. But again, never physically interfere, never lie to the police, and never affirmatively hide information from the police, because that may be obstruction of justice and you may end up going to jail. Remember, when you're making disclosures, HIPAA says even though you can disclose information to the police, you can't disclose more than is minimally necessary for that purpose. So in all of those exceptions, they generally have the type of information you can disclose or the purpose for those disclosures. Don't disclose more than is minimally necessary. If you do, that is a separate HIPAA violation. When you make the disclosures to the police, HIPAA requires you to log certain disclosures so that if the patient wants to come in and get an accounting of the disclosures you've made, you've got this log that tells the patient the date of the disclosure, the name and address of the entity receiving the information, the description of the information disclosed, and either a statement of the purpose of the disclosure or a copy of the written request for the disclosure. The bottom line here is when you're disclosing information to the police, generally all of those are subject to that disclosure log. So that means when you're making disclosures to the police, you have to log that in this accounting of disclosure log. So if the patient ever wants to come back and get a copy of that, you've got that recorded in that accounting of disclosure log. Now, patients rarely ask for that accounting of disclosure log, but that doesn't mean that you can avoid it or ignore it. If you do, then you run the risk of HIPAA penalties. Note that you have to log that disclosure even if HIPAA allows you to make the disclosure to the police. You still have to log it. There's only limited exceptions to making those, logging those disclosures under the exceptions for HIPAA. So make sure that you're familiar with that. Now, when you maintain that accounting log, the patient has a right to come in and request that. There are certain limited circumstances that the police may now want that patient to get information that they're investigating the patient. If that's the case, they can tell you not to disclose that accounting log to the patient. If they tell you that, then you can suspend your obligation to make that disclosure to the patient, to provide that written accounting log to the patient. If it's in written form, if it's a written directive from the police, and they confirm that the accounting would reasonably be likely to impede the agency's investigation, then they can tell you how long to suspend that and not to disclose it. You can comply with that written request. If it's simply oral direction, then you can only suspend that the response to the request for accounting for up to 30 days. This occurs very seldom because very seldom do patients ever come in and request an accounting, but in the rare case that this ever were to occur, you've got the rule now. Well, what happens if you breached your obligation? You find out that one of your nurses disclosed information to the police in violation of the rules that we've talked about. They disclosed more than they should have, or they made a phone call when they shouldn't have. Well, under HIPAA, you have an affirmative obligation to report a breach of unsecured protected health information that violates the privacy rule. You've got to report it to the patient or personal representative within 60 days. You've got to also report it to Health and Human Services, HHS. The timing depends upon the number of persons affected. In certain circumstances, you also have to report to the local media if the breach involves more than 500 persons in the state. Now, the key here is you only have to report it if it is a breach as defined by HIPAA. Now, the accounting log, you have to maintain that log even if it doesn't violate HIPAA if you're making disclosures to the police. The affirmative obligation you have to narc on yourself to the patient only applies if there's a breach of unsecured protected health information. Breach means that you violated the privacy rule in disclosing that information. And under the privacy rule, here's the standard. The unauthorized access, use, or disclosure of unsecured protected health information is presumed to be a reportable breach unless the provider can demonstrate that there is a low probability that the data has been compromised based on this risk assessment of these certain factors. So if you think there's a breach, you need to contact your privacy officer and work with the privacy officer to give the required notice within the time period. Now, just like on the accounting log, if the police tell you that they don't want you notifying the patient because of an ongoing criminal investigation, then you can suspend that obligation and make that report for a period of time. If it's in writing, you can comply with whatever period of time the police state. If it's simply an oral request, you can suspend that obligation to report for 30 days. Hopefully within that 30 days you can go back to the police and get a written statement. Otherwise, you have to go ahead and give the notice to the patient. Ensure your business associates comply with these rules. They've got to comply with the HIPAA rules just like you would. When you're applying these rules, remember we've only talked about HIPAA. There may be other rules out there that limit or allow you to prohibit disclosures to the police. Maybe it's attorney-client privilege, work product doctrine, peer review privilege. Certain drug and alcohol treatment program records are not disclosable to the police either under state law or if you're a federally funded drug and alcohol treatment program under federal law. So make sure if you are a drug and alcohol treatment program that you're aware of those rules that apply in those situations. All right, that's a brief overview of dealing with law enforcement. If you want additional resources, again, we've given you a lot of handouts. There's also the AMA has published, or the AHA, that should be the AHA, has published guidelines for releasing patient information for hospitals. You can access it on the internet. The Utah Attorney General has a whole section, a website dealing with HIPAA issues, including it has copies of that, the guide that I handed out or I provided to you. The OCR's website has a wealth of information, including FAQs dealing with law enforcement. On our website for Holland & Hart, we've published a lot of information dealing with HIPAA, including the client alerts that I provided to you today dealing with law enforcement and also responding to subpoenas. And I think that that is it. I have 12:58. If there are any questions, feel free to go ahead and send me those either by the chat feature, give me a call or Blaine a call, or send me an email. We'd be happy to respond to that. Other than that, this program is recorded in case you ever want to use it for training in the future. If not, we wish you the very best and good luck as you deal with law enforcement in the HIPAA context. Thanks very much.